Hello everyone and welcome to this session on M&A due diligence in data protection. My name is Eleanor and I'm a lawyer at Fieldfisher in London, and with me is my colleague Charley Guile. This is part of the Get Data Protection Fit series. So far, we have looked in Module 1 at the fundamentals of data protection law. And then we've also looked in Module 2A at putting data protection into practice. And now we're at Module 2B. And we're looking in particular here at Segment 4, M&A Data Protection Due Diligence. So what are the learning outcomes for this session? Well, by the end of the session, you should be better able to explain the role of data protection in M&A transactions, that's mergers and acquisitions, explain the impact of due diligence and the risks associated, and finally, mitigate any risks that you have identified. So what's the structure of this session going to be? Well, first we'll look at the context at data protection in an M&A transaction. And then we'll go on to look at the roles of the buyer and the seller. And then we're going to dig a little bit deeper and look at how due diligence is done in practice. And then finally, how to deal with any risks that you've uncovered in that process. So why is due diligence important in an M&A transaction? Well, it really is key to know what your risks are prior to the transaction. Everyone has data in their business nowadays, so looking at the data protection compliance in the target, in the business that you're buying, is absolutely key to knowing potentially what the price of that target is. Is the data protection compliance such that in fact it really has an impact on price? That's not going to be the case most of the time, but you really want to go into this transaction with your eyes open and not have any unpleasant surprises further down the road. Once you've carried out your due diligence, you may have a schedule of work that you need to do post-completion. Most companies aren't entirely data protection compliant, so it's very likely that there are some gaps that you'll need to fill in the compliance framework. That's completely normal and part of the process of ensuring that this transaction is going to go the way you want it to, and that this business that you're purchasing is going to complement potentially your other businesses and not cause any regulatory risks for you. It's really important that you look at this because you don't want data protection to scupper your deal. So there was a study done in 2018 which discovered that 50% of transactions were actually undermined and didn't go ahead because of concerns about GDPR. That doesn't need to happen if you've done your due diligence properly and properly assessed the risks. So it's important not to let data protection scupper your deal, and hopefully we'll give you the tools to ensure that that doesn't happen in your transaction. And finally, from the point of view of the seller, everyone's dream is to build up a business which they can then sell on in due course, which is working well and is profitable and is an asset. So data protection is actually a good investment because when you come to sell your business, everything will look right from a compliance perspective and you won't get friction in the deal because of the way in which you've done your compliance. So due diligence is important from that perspective too. So now I'm going to hand over to Charley to talk a bit more about data protection in an M&A transaction?
Thanks, Eleanor. So before looking specifically at data protection in an M&A context, just a reminder that there are 7 basic stages of the transaction, and for different deals, these will overlap or might be very, very separate. But as a rough guide, they'll be the heads of terms or the letter of intent. Both parties will negotiate at the outset. And the parties will enter the stage of due diligence, which is the focus of today's session. And then following this, there'll be the drafting of the main agreement, whether that's a share purchase agreement or a business purchase agreement. And as part of this, there'll be the warranty negotiations. There'll then be the opportunity for the seller to prepare a disclosure letter to disclose against any of those warranties. And then the parties will enter, provided everything's okay, will enter towards exchange and completion. And these may happen as being a split exchange and completion or simultaneous. And then there'll be the post-merger integration, so where you integrate that target with your company. So looking at data protection in the M&A context, there's a raft of considerations we could focus on. There are lots of issues, for example, around disclosing documents to the buyer and ensuring that that disclosure is limited to what is actually necessary. Are there particular documents which would need to be redacted because they contain personal data? And as a seller in this matter, there are lots of things you should consider, including sort of the legal basis for disclosing any of that data, who would have access to that data. And although these are not covered in today's webinar, these should be considered before disclosing any personal data. So our focus today is due diligence, what this entails from a data protection perspective. Whilst the structure of the deal may vary, our focus and what we're talking about is primarily sort of share purchase agreements, whereby the buyer comes along and purchases the controlling interest of the target. The deal could also be structured as an asset purchase. So the buyer comes along and cherry picks the assets they would like, and then tries to get rid of any liabilities and not take those on which they do not want to. And depending on the types of assets involved, a lot of what we discussed today could be crossed over and might be covered as part of an asset purchase as well. So looking primarily at due diligence, what is it? Now, as the slide helpfully says, it's a process whereby the buyer can ask questions to elicit as much information and gather as much documentation as they can about the potential target. As Eleanor did mention, it's really important to know what you are buying. You don't want to go into this matter blind. So this is your perfect opportunity to get as much information as you can. And this probably isn't just to do with data protection, it's to do with any other area of the business. But right now, data protection, there could be items and particular things you want to ask for. So you probably want to review key documents they have in place. There might be policies and procedures. The OGL question of any breaches, have they happened? And there'll be lots of other documents which you will request. And part of this, you'll be looking to highlight any potential issues there may be with the target at this early stage. So looking at the roles of the two parties and the due diligence, as a seller, you might think your role in this is pretty easy. You've just got to get your house in order. As Eleanor mentioned before, actually data protection compliance is a really good investment. It probably takes a lot longer to try and do it after the matter. And when you're trying to get to sell and there's a tight deadlines, than it is just to be doing it as you're developing the business. Now, as a seller, you need to be prepared for providing disclosure to the buyer. This includes having teams on standby to respond to questions, having relevant documents ready to be uploaded to the data room. It is much easier to have the documents uploaded at the outset rather than the buyer having to ask for everything all at once. And also anticipate any warranties that the buyer may request and what effect this could have on you as the seller. As the buyer, and primarily our focus of this session, as there is probably a lot more weight on your role in the due diligence, as Eleanor mentioned, there are several reasons why this process is really important and why this is going to need to be at the forefront of your mind. The saying sort of buyer beware is important here. Do you understand what the target has and what data they process and what activities they are doing with the data? Do you understand the sort of compliance efforts or lack of them? Any sort of governance within the target? And with that, are there any potential risks? You want to know at the outset what these could be. As the second point on the slide highlights, as the buyer, you are taking on all these risks and liabilities of the target. you need to know what's going on. The example that Eleanor mentioned of the risk and stuff you're taking on. The example is Marriott, where there's a huge breach post-completion. As much as possible, you need to know what things are hiding in the woodworks. And then this helps you understand what does need to be resolved. So are there items that you need to resolve before you actually complete? Are they significant and fundamental that you wouldn't want to complete without them? Often there are items which actually you're happy to deal with post-completion, but they're easy enough just to add to your schedule of work that you're going to deal with. But if they are so significant that you want them to be dealt with pre-completion, are they actually enough to affect the price? Do they affect the value that you've placed on that target? And will there be further negotiation between you and the seller?
Thanks, Charlie. So now we're going to delve in a bit more depth into due diligence in practice. How do you conduct it? Well, it's not going to be a one-size-fits-all process. So first you need to look at the business that you're looking to buy. What sort of data does it hold? Is it minimal? Is it low-risk data? Is the target that you're going to purchase not really a data-rich business at all? It does something completely different. So really, the data component is a very small part of that transaction. If that's the case, then you don't want to be putting masses and masses of resource into your due diligence process. But at the other end of the spectrum, you might be buying a business which is, for example, in the AI market. It's data rich. Potentially it has high risk data and large volumes of it. It's going to be absolutely crucial that you understand how that data was collected. What is there? What is it that you're going to be buying? What are the risks associated with it? And your due diligence process, as a result, is going to have to be much more thorough and much more careful and resource intensive. So one size fits all doesn't work here. It's about the nature of the target and also the value of the data to the business in question. So we're now coming to the due diligence questionnaire, which is really how you start to unpack the detail of what data is being held and how it's being held and how compliance is being conducted. So it's not, unfortunately, a question of just, is the target compliant with GDPR? Yes, it is. So your questionnaire is going to have to look at issues like, are there Article 28 terms in place with the processor? Are there records of processing, and what do they look like? What's the legal basis for the processing? For example, if the processing is done on the basis of consent, is that valid consent? How is it collected? Have there been any breaches reported to the Information Commissioner's office? If so, how many? Is there a record of breaches? So those sorts of questions will be really important. And again, going back to the context of the deal and the importance of data to the business that you're purchasing, the question is something relatively high level enough because this is just not a data-rich business? Or do you need a really detailed questionnaire to flush out all of the issues? So I'm now going to hand over to Charley to talk about the follow-up questions and what to do if you uncover risks as a result of your questionnaire.
Thanks, Eleanor. So as part of the seller's answers, there is likely to be sort of disclosure of some information, and as we said, sort of documents related to the data room. And this could be, for example, please confirm that there are Article 28 terms in place, and by virtue of that, the seller provides you with a whole host of supplier terms in the data room, which is great. You've now got them, but what do you actually need to do now? So these answers and all those documents are nicely placed in the data room actually need to be reviewed. There's no good just relying on the fact that they're there or that the seller has responded to something. You need to actually go through these and at the first stage, maybe follow-up questions. It might be that the answer provided isn't actually any clearer. It doesn't give you the answer you were looking for or you're not able to understand. Equally, there may be that some of the documents uploaded aren't what you're looking for, or raise further questions about what other things you might require. So you'd usually get an opportunity to ask follow-up questions. This is, of course, still dependent, and if there's a very tight timeline, this may not be in scope. But crucially, what you want to do here is avoid asking the questions you've already asked. So, as Eleanor mentioned, making sure those questions you ask at the due diligence questionnaire stage are tailored to the target, to avoid you having to go back and answer even more questions this time. This should really just be a follow-up exercise and not a rehashing of the due diligence questionnaire. It's crucial here to just make sure as well that everything which is possibly a concern to you is covered off and you've got as much information as you can. Once you've received those responses and you've reviewed that additional documentation, you're now in a position to sort of assess any risk there might be with the target. You should review all of these items and sort of take your own view on the compliance of that target. So just because the seller's response to whether they have any Article 28 terms placed with their suppliers is yes, and they've uploaded all those documents to the data room, does still mean you should review those just to check those terms are as robust as you would like them to be, or whether there's something glaringly obvious that's missing. And once you've highlighted any risks or gaps and concerns, you need to assess these and whether they are simply items that you can deal with to a post-completion to make sure that they are in line with the rest of your organisation, or that actually they're high risk and could potentially undermine the transaction. And then we get to the report stage. So at this point, it's a summary. You create a summary of any of the information that you've gleaned and any risks you identified from your due diligence, and present this could be internally to particular members of the deal team who will be closer to the transaction as well to be able to review this, and they can assess what the outcome will be. And then finally, it's the opportunity to deal with any of these risks. So what do you do? Just because you've identified them, do you just leave them? Are they just, okay, I've red flagged them? There are actually things you can do to mitigate these. So first one on the slide is warranties and indemnities from the seller. So if you have identified some risks, you could look to obtain a warranty from the seller. And in some cases, if it's severe enough, it might be an indemnity that you request. And we could spend a whole webinar just discussing the differences between these two terms under English law and the suitability in this situation. And it will be very dependent on what the matter is in front of us as well. What is important to note here, that just because you've got a warranty or indemnity, this is not fail-safe. You still have obligations and statutory obligations on data protection laws, and therefore you'll need to rectify any of those risks and items you've identified post-completion. It's not enough just to say, oh, don't worry about it, we've got a warranty from the seller, so we haven't got to be concerned with that item. This leads into sort of the next point, which is issues to resolve post-completion. It is likely that there will be items which you do want to pick up and rectify. Some of these items may just be picked up generally in terms of integration, so ensuring that all your privacy notice looks the same, or everybody's on similar security requirements. But equally, there may be small minor things that you might be happy just to pick up and resolve post-completion, and you can be added to the schedule of work that Eleanor mentioned at the beginning. There may, in some scenarios, be the items to be resolved pre-completion, and that is a matter of you reviewing what risks you identified, working out how severe they are, and whether they do actually undermine the transaction at all, or it would make it worthless. So, for example, if you had a data-rich direct marketing company, if that organisation had very little to show its compliance efforts or consent from the individuals, the actual purchase may be valueless. If you haven't got any ability to use any of that data, you may think, actually, we need this to resolve pre-completion. And tied into that, it might be price. So linked in with that point on the data-rich marketing company, you might say, actually, we need something to be renegotiated here on price, because actually this is a fundamental issue that renders our purchase valueless at the moment. So as we're drawing to the end of this session, you should now be equipped to explain the role of data protection in M&A transactions and explain the impact of due diligence and some of the risks associated with the process, and be in a position to look to mitigate some of those risks that you identified during the process. Thank you for taking the time to listen to our webinar on M&A and data protection due diligence. This is part of our module 2, and there'll be further modules, so please do subscribe to our YouTube channel so you can be notified of when our next module goes live. We look forward to you hearing some of our later webinars. Thank you.